Good morning, everybody, and thank you for joining me. This is going to be a webinar on opening statements, which I will tell you I think is the most difficult part of any trial. I'll tell you why. For those of you who don't know me, my name is Mike Rafi. I appreciate you joining me this morning. If you don't know me, please reach out. My email is mike@rafi, R-A-F-I, lawfirm.com. Email me. Introduce yourself. Tell me who you are. Tell me what you do. Tell me what kind of cases you'd like me to refer you and look out for, so that way I can send your way. And let me know if I can help you. I've had an awesome time these last 2 months now, maybe more than that since I started doing these, with talking to people about their cases. I was in the car yesterday for a couple hours, and I spoke to 2 or 3 people about all different cases, and it filled up my drive time, and it was a lot of fun to get to know some folks and hear about your cases. So let me know what I can do to help. But let me spend some time here helping you, hopefully, and talking about some opening statements. For those of you who don't have a ton of trial experience, which, I mean, nowadays it's really, really tough to get trial experience in a civil setting, at least a jury trial experience. Criminal cases, if you're a public defender or a prosecutor, a little bit easier. But on the civil side, it's tough. It's tough. My firm, we say we do a lot of trials, and I'll be honest with you, we do 4 to 6 a year, and that seems like a lot. Our trials are usually something like a couple days, a week long. So there's people on here. I saw Robert James on here earlier. I don't know if he's back in the room. He is. Robert has probably done more trials than maybe everybody else combined, depending on who's on this list. So we're all learning this together. So let's start with the very, very basic premise, which I don't think you can win your case through an opening statement. I hear that all the time from some really smart people, that you will win your case in opening statements. No, you won't. No, you won't. You won't win your case in the opening statement because what the lawyer says is not evidence. You can't present evidence. You can't put up any witnesses. All you can do is just talk. What I think really happens is you present a good opening statement. You then go through and you prove all the things in your case that you say you're going to do in your opening statement. And then you close, and then the jury delivers a verdict for you. And then the jurors look backwards in time and say, oh yeah, I was with you from opening statements. I was with you from back then. Well, they weren't. They weren't. They were with you as you went through and proved your case. So I would respectfully suggest to all those smarter people out there, people smarter than me who think that you can win your case in opening, that the only thing you can do in opening is lose your case. And you can lose your case by making promises that you don't deliver, by being unlikable or a jerk, and by not putting a larger burden on the defense, which I'll walk you through and how you'll do that. But at its most basic, an opening statement is like telling a story to a child, or explaining a movie to a friend, or telling a family member about a book you're reading. If you have done any of those things, maybe you've even gossiped a little bit with friends. If you've done any of those things, you can give an opening statement. You can do that. What I'm going to do is show you my standard, repeatable process, topics and categories for my opening statements. And I'm going to show you some openings dating back to 2016, I think, 17, that show you that I've used this, and will show you how I've done it. So here is the repeatable process. The first thing is a win statement. The second thing is your theme, followed by the importance of the case and introducing your client. Then you're going to tell your story. You're going to give very briefly the law and explain what the elements are. What are the things that you need to accomplish? You're going to show how you will meet those things. Talk about the damages in your case. You will see that number 8, 10, and 12 are all the word ask with a question mark. The reason for that is because more and more I am of the belief that you should tell the jury how much you are going to ask for in your opening statements. Where you do it, I think, is up for some debate. So it can be after you have told the jury about the damages to your clients. I mean, think about the transition. Here are the injuries, and as a result of those injuries, we are going to ask you for whatever. If you don't do it then, or even if you do, I think the next thing in number 9 is that you are going to address the defense case. You're going to force their hands in certain ways if you need to, and ask them to do something if they can't. I'll show you some examples of that. You can then ask for money. You can give your theme and then ask for money. And then you're always going to end with your win statement. You're always going to end with your win statement. So that is the repeatable process that I use. Kelly Casey, who is the advocacy director at the University of Georgia Law School, told me she was going to be on this webinar, or at least she's going to listen to it later. I did moot court and mock trial in law school, and I did mock trial in undergrad. I was using this repeatable format minus the ask and damages, because you don't have those in mock trial or moot court, or in mock trial at least. I was using this formula then. I think it works. It's pretty straightforward. It's pretty simple. It gives me confidence that I know what I'm going to do, how I'm going to do it, and it gives me something to fall back on. So let me walk through or explain to you each element of this. And I want to start with the win statement. And keep in mind, everybody, I'm going to send you an email and it will have those 13 things listed. So don't worry. So let's start with the win statement. What the heck is a win statement? A win statement is a single phrase, sentence, whatever, that if true means you immediately and must win the case. Let's say that again. It is a single sentence or statement that if true will win you the case. Let's say it one other way. It's a statement that if the jury believes, they must find in your favor. When we do intakes in my office, most our intakes are pretty straightforward, but the ones that are complicated, I will only take the case if I can understand it in one sentence, because I think that juries can and must only understand things in one sentence. So that's what this is really about. It's having one central statement that if you prove it to be true, you will win your case. I want to show you some examples. So this is a program called Prezi, P-R-E-Z-I, Prezi. It is PowerPoint on steroids, plus HGH, plus, I don't know, some hype man yelling up and down and pumping you up. So if you can guess what my theme was here, this is a trial from 2000 and, God, I'm so bad with dates, 17 or 18, something like that. My theme was, or excuse me, my win statement was a broken promise. If I prove to the jury that the other side broke their promise, I win. The broken promise here, it's a UM case. So the broken promise was failing to pay the damages, failing to pay their own customer. The insurance company defended the case in their own name. So the win statement was, I forget the insurance company. Encompass had a broken promise. If I prove that, I win every single day of the week. Here's another one. This was a gas station shooting in 2017, maybe 18, resulted in a $1.7 million verdict, plus attorney's fees and some other things. But our win statement was that the defendants ignored warnings and invited danger. They ignored warnings and they invited danger. If they ignored the warnings that they were told of about the dangerous activity and crime going on the property, and in fact, if they invited that danger onto the property, I win the case. I win the case. Last one, old school, PowerPoint. My client's name was Tommy Wynn. Tommy Wynn did what he was supposed to do. Tommy Wynn did what he was supposed to do. If my client, Tommy Wynn, did what he was supposed to do, I would have won the case. You all know I'm always going to be real with you. I tried this case in November of last year, November of 19, asked for $6 million, first goose egg. And the reason was, by the end of the trial, the jury did not believe that Tommy did what he was supposed to do. Maybe they were right. Maybe they were right. So, this is the bar that you're setting for yourself. Would I go back and change this win statement? Maybe. But the question is, should somebody win their case if they weren't doing what they were supposed to do? Maybe not. As a style and a visual note, you will see that I'm doing these visuals. This is an old school PowerPoint. I've got my two prezzies, and I'll show you about those. But the background's black and the lettering is white. Why? Stupid reason, but a good reason. I want the lights on in the courtroom because I don't want the jury to go sleep. So a black background with white lettering will actually make the lettering stand out more. So you can dim the lights or even leave the lights on and the jury can see much more clearly, much easier than if you didn't do that, if you reversed it and had black lettering, a white background. So that's why I do that. So we've got our win statement. And our win statement is the first thing that I'm going to say to the jury. Literally, the first thing. I'm going to stand up. I'm going to take my position right in the middle of the room, right in front of them. I'm going to put my arms down. I'm going to show you this. Give me 1 second. I'm going to put my arms down. I'm wearing shorts today. I'm going to put my arms down at my sides. I'm going to put one foot a little farther in front of the other foot so I have a good base. I'm going to put my shoulders back and I'm going to drop my hands. And I'm going to feel really awkward because I'm just standing here like this. But hopefully, if you weren't looking from this weird angle, I would look pretty natural. What I'm not going to do is keep my hands up here like a dinosaur. I'm not going to keep my hands up like this. I'm going to put my hands down. I'm going to make one motion, drop. One motion, drop. Two motions, drop. And for the most part, I'm going to stay in this box, which I'll call a gesture box, right around here. If I want to go wider, I'll do that, but it will be very rare. I'm generally going to stay in here. So I'm going to stand up right in front of the jury. I'm going to pause. And then I'm going to say my win statement. They ignored warnings and they invited danger. And then I move my hand down. I'm probably going to say it one more time. They ignored warnings and they invited danger. And then I'm going to tell the jury this. People say you have to say things 3 times to make other people remember it. So, ladies and gentlemen, they ignored warnings and they invited danger. What I'm doing there is I'm repeating my theme, my win statement. I'm repeating my win statement. And I'm also telling the jury, I'm repeating this. Remember this shit. Remember it. So, after I get done with my win statement, I am then going to go to my theme. What is a theme? To me, the theme is the overall concept and feeling of the case. To me, there are only a few themes in the world. There is revenge. There is righting a wrong. There's responsibility. There's choices. There is compensation, making something right. Those are about it. Those are the only themes. I mean, that's what life is. There's only those things going on in life. So what I want to do then is tell the jury that this case is about responsibility. This case is about righting a wrong. So what I've done is I've told them how I'm going to win the case. I'm going to prove this win statement. And here's the concept that I want you to know about for this case. It's kind of like if it's a movie, hey, here's a romantic comedy. This is an action film. Well, that doesn't mean that you're going to like the action film. That's my win statement. if I want you to like something, I'm going to give you a statement about it and I'm going to make you believe it, but then I'm going to give you the context for that statement. And that's my theme. So after I get done with my theme, and I'm going to show you before I get done with my theme. Here's my actual script from the trial in November. First page, by the way, is my needs page. That way, if I get up there and I need something, well, the first thing I do is I look at the needs and see if I need something, because I put a list. And if I need something, I make sure I have it before I stand up. So I'm not midway through my opening. And then I find out, oh, shit, I forgot to pick that up from the table, or that's in my file. What I do then is literally, Tommy Wynn did what he was supposed to do. He was driving. He was hit by somebody and hurt. He followed the doctor's orders, had 4 surgeries. All along the way, he did what he was supposed to do. My theme was a little later in this one, but it would typically, and I think I said it this way, it goes here. This case is about taking responsibility. The company that's responsible for the crash and Tommy's injuries has refused to take responsibility. There's my theme. Here's another one. They ignored warnings. They invited danger. It culminated in a shooting where my client was hurt. This is an important case because this case is about safety. It was a gas station shooting. Every time you leave your house, every time you go to a store, you have a right to be safe and feel safe. And that's what this case is about. Giving you the win statement, I've given you the theme. Okay? So after we do that, then we go into the importance and the client intro. The importance of the case and the client intro. I think that when jurors walk in, I know when jurors walk in, they don't want to be there. They think this is bullshit. I have to go to jury duty. And you ever know anybody under the age of 65 who's excited about going to jury duty other than lawyers? Nobody wants to go to jury duty. They're pissed off. They have to leave their family, leave their job. They get paid pennies. They have to sit there in some room. Pretty soon, they're going to have to sit in that room with somebody who definitely has coronavirus, and that's what's going to happen. And then they got to be herded around from meeting room to a courtroom where they sit and they get asked personal questions, which isn't fair to them. They don't know if this is going to take 2 days, if it's going to take a month. So what I'm looking to do in the third part of this is to make them care as much as I can. I don't believe I can make a jury truly care an opening. And I tell them that. But I want to tell them that this case isn't a bullshit case. It isn't some, case that doesn't matter. This case does matter. It's important to everybody in the room, and it should be important to them. Let me show how I would do this. So I'm going to go to one of the prezzies. If I can get there. Here we go. So I start by zooming in. I say my win statement. They ignored warnings and invited danger. This case involves an important question. It's an important case. Here we go. So here's the importance. This case is important and it involves an important question. So the importance is that of this case, at least, is that it's important to the parties. It's important to my client. Here's who my client is. He cares. His family is in the courtroom. They care. It's obviously important to the defense because they hired the best lawyers that money can buy. You always want to do that. You always want to, on your case, you want to under promise and over deliver. On their case, you want to talk it up. You want to say those lawyers are great. They did everything they possibly could. They have the best case money can buy. You're setting their bar so high, and then hopefully they can't meet it. Hopefully they can't meet it. Now, of course, if this case is so important, it has an important question that you must answer. Here's it's important to my client, the gas station, the defendant, and I say to the jury, I hope at the end of this case, because I don't think it's important to you right now, but I hope by the end of this case, you'll agree with me that this is really damn important. That important question I told you about, here it is. Is it acceptable for someone to get hurt because a business ignored warnings and invited danger? And your answer matters, not just to the people in this room, to everywhere. Now, that last part, can you say that? Maybe. Maybe. You can if you don't get objected to. Let's look at it here. This case, remember, it's a UM case against the client's own insurance company. They didn't pay the policy. So this case is about a broken promise. It's important. Has an important question. It's important to the clients, the defendant, and to you. Same formula. Here's the important question. Is it acceptable for an insurance company to break its promise? Same formula. Same formula. Here's the important question in Tommy Wynn's case. Remember, the theme is about responsibility. So is it acceptable for a company to blame someone, or to blame someone who was just doing what he was supposed to do? I'm incorporating my Wynn statement and my theme in the importance. I'm incorporating the Wynn statement and the theme in the importance. So we've gotten through a Wynn statement, we've gotten through the theme, and now we've just finished up the importance and the client intro. And remember, during this, you are putting a burden on the defense. You are telling the jury how great of lawyers they are and how they did an amazing job through the case, even if you don't think that. When you introduce your client, by the way, you got to make sure you tell them you're going to introduce them. Make sure they know that you're going, that they're going to be on. I mean, it's kind of a play that they're going to be on stage the entire time. And especially when you introduce them, they need to be ready and they need to know what to do. We spend a lot of time with our clients helping them get ready for that moment, because that is their intro moment to those 12 jurors or 13 jurors. What I'll tell you, and feel free to steal this. What I typically say is something like this. Sitting over there is Joe Smith. Joe Smith is my client. I don't walk behind them. It just makes me feel weird. I don't put my hands on their chair and this is so-and-so. Maybe in the right setting I would do that. It just it creeps me out. If it works for you, go do it. But I say, that's my client, Joe Smith. Now he's sitting over there and he looks calm, cool, and collected. And you know why? It's because I told him he had to be calm, cool, and collected. But on the inside, he is jumping up and down with excitement. Because today, after all these years, is his day in court. It's a purely American concept. It might be the most American thing that we have. It's his day in court. And he's been waiting all this time. And he's putting his trust into you. And that's the transition to the importance to the jurors. He's putting his trust in you, 12 strangers he doesn't know, which I would tell you shows you how badly, how unfairly he's been treated. Because would you go to Walmart and pick 12 random strangers and ask them to decide something really important in your case, really important in your life? Should I get married? Where should I move? Should I quit my job? Hell no, you're not going to do that. But Joe Smith over here, I give him a lot of credit because he's trusting you. And you have incredible power and responsibility. So even if you don't think that this case is important to you right now, I hope it will be, because you have incredible power. I'm jealous of that power because you have the right, the ability, and the responsibility to make things that are wrong, make them right, and to do what is necessary here. So that's usually my opening introduction to the client and the wrap up of importance. The next thing I'm doing is telling the story, and I'm just telling it like I'm telling a friend. If you tell your friends about stories, if you tell your family about your cases, if you tell whoever about any of your cases, that's all you're doing. That's all you're doing. Now, if you caught my tip of the day, well, actually, I guess my tip of the day will be Friday. It's going to be a tip of the day on attention spans. I give you all a lot of credit for hanging with me for an hour once a week, because I don't know if I'd have the attention span for that, and I don't think our jurors do. So I've shown you our presentations, and the reason we do those presentations is because I think jurors expect some sort of visual. We live in a visual world. I mean, Instagram and Snapchat and Twitter and all that stuff. I mean, podcasts are coming back, but most times people want to see and hear things. So old school visual, I say to the jury, let me tell you about the crash. I'm showing photos and I'm just talking about the crash. Here's where they were driving. This was the vehicle involved. Here's where they were driving. Here's how the road works. These arrows pop up left and right. Here's the damage to the vehicle. Here's what the police officer said. And that's the end of my story. In a Prezi world, it's a little more exciting. So this is the broken promises case. So we've just gotten through the important question. We zoom out and now go to the law and what you need to know, what you can do up front, and then the evidence. So this kind of just pops up evidence, and then here are my 4 witnesses. 1, 2, 3, 4, and von Schlegel, Todd Greer, the officer, and then my clients. And each one has a little bubble. This was an eyewitness. They called 911. They thought my clients were going to be killed. In Rosebud, you'll see the same thing. This is the theme slide with the important question. And then it goes to the law, what you need to know. Here's who everybody is. And then it goes to the story. I think in your standard car accident, though, what you want to do is you want to give the story because the jury needs to know. So if you look at my list here, remember, there's no perfect way to do this. Story and law, 4 and 5, those can be reversed. It really depends on what you want to do. It depends on the flow you think. When you get to the elements, well, let me back up. When you're at the story, you want to make sure everything you say you can prove. Absolutely everything. Everything. You want to make sure that you want to make sure that you are 100% sure that the jury is going to hear whatever you talk about. So if it's calling a witness, you need to make sure that that witness is actually going to show up. If it's a piece of evidence, you need to make sure that the judge is going to allow the evidence in. So my recommendation to you is if there's something that you don't know, if the jury will actually hear about it before you're opening. So before you're opening, if you don't know you're going to be able to use this piece of evidence or that witness, you either need to get a pretrial ruling so that you know the answer, or you can't say it. You cannot say it. If you promise things and you don't deliver, you will lose your credibility. There's no doubt about that. And if you lose your credibility, you will lose the case. So save your credibility. Only promise things that you absolutely can deliver. When you go through the law, you want to present the elements as well as you want to be the authority in the courtroom. You want to tell the jury what is going to happen so that way they can rely on you and they know that you're an expert in what you do. For any of you people who've watched these webinars before, I talk about being an expert in the courtroom a lot. The jury has no idea if you're in the courtroom once a week, every day, or once a year, or every 5 years. They have no idea. They assume, though, you were a lawyer and you know what the hell you're supposed to be doing. So you need to show them that, especially if you're the plaintiff's lawyer, because you have the first opportunity, whether through jury selection or through the opening statements, you have the first opportunity to present your expertise of the case and yourself. So what I like to ask the jury or tell the jury, I like to say to them, I'm going to show you what you need to know about this case. Here are who the parties are. There's something called the preponderance of the evidence. It means more likely than not. It means if there's scales, you have to tip one a little bit. It means the scales are equal and then you put something over here. It means anything more than 50%. However you want to say it. I like more likely than not, but whatever. I think you want to contrast this with a reasonable doubt, how that's way higher, way, way higher. Negligence. We hear a lot about negligence. You want to tell the jurors that it's very, very simple. It just means that the defendant act reasonably. Were they acting like a reasonable person, presumably like you? The 4 elements of any tort, duty, breach, cause, damages. I I think you have to show these to the jury because at least in my world, my closing, I'm going to have these 4 things. I mean, that is my closing. Here are the 4 elements. Here is how I met them. So I want to introduce this idea very early. You're going to have all different types of evidence, statements, stipulations, explain what those are if needed, witness testimony, exhibits. We're going to show you everything we need to show you, everything you need. Here's where I'm going to tell the jury that I'm going to respect their time. So we're going to show you lots of evidence. I usually point to all the boxes, all the files I have, because I bring every shred of paper and I'll print off all the shit. I bring everything I can. I stack them up. I'll actually tell you a real quick story. In this case, this is the other Prezi, the broken promises case. It was a very simple case, like really simple. It was a hit and run case. There was a police report. That was about it. And then there was damages info. So I brought 7 empty boxes to court. I put stuff in them, so that way they seemed heavy, but there was nothing of substance in them. I brought books and some supplies, food, whatever, because I'm not showing up to court with no boxes, because I want to be able to point to the boxes and say, that's all the work we did for years. Thankfully, though, I'm going back to this other one. Thankfully, though, what we have done is we've taken the evidence, the statements, the stipulations, the witness testimony, the exhibits, and we've taken all these boxes and we've figured out for you what the most important stuff is, what you need to know. And we're going to show you what you need to know, but we're not going to show you what you don't need to know. Because you look at your boxes and you say, because showing you what's in every piece of those boxes would take months. But your time is valuable. And I promise to you 2 things. I promise I'm only going to show you what I absolutely need to show you so that you can make a decision. And it'll be everything. I'll show you everything. And number 2, I'm going to move this case as fast as I humanly can so you can get back to your work, to your family, to your lives. I make that promise in every case, and you have to live by it. You have to live by it. So you have to be prepared with your witnesses. You have to be prepared with your exhibits. You have to have your crosses and directs really, really condensed down to what actually matters. Because those 12 people will sniff you out if you're not prepared and you're wasting their time. So I make those promises when I talk about evidence. After that, I then go through the story. I went through the story here, but I like to go through the story by, and the reason here is because there's a video, which you'll see. So here there was a video, so it was a little different. I'm not going to play the video for you, but with that case, I was talking about the broken promises. So here's how I'm going to meet the duty, breach, and cause. I'm going to show you these witnesses. They're going to say this, this, and this. I'm going to meet my elements by showing you this, this, and this. All right. So let's take a look back at our repeatable system here. So we've gotten through 1 through 6. We've done our win statement and theme. We've told the jury how important the case is to the client, to the other side, to us, and to them, meaning the jury. We've told our story. We've introduced the law, what they need to know, and make sure that you say that law exactly how the judge is going to say it. So, I mean, look at your jury charges, because that builds you credibility when you can say the judge is going to tell you this. You look like the oracle. They don't know that you write the jury charges for the judge. And then you're going to talk about your damages. So you get through with your story, and then you're going to talk about your damages. You want to tell the jury everything you can prove, but you want to tell them the most important things. If your client was healthy beforehand, tell the jury. Give them the starting point. If your client experienced pain right at the scene, you want to tell the jury that. If they have significant injuries that are objective injuries seen on imaging, bulging and herniated discs, torn discs. You can see, depending on the imaging that they do. Here they did a discogram. Whether they should have not, I don't know. But here you have herniated discs and bulging discs, and you have discs torn. I use the jelly donut analogy. If you haven't ever heard Dr. Bendix talk about the jelly donut, I can share that with y'all later. But I'm talking about what the images or what the injuries are. I'm then talking about what the treatment is. Went to a chiropractor, did what they were supposed to do. Injections, did what's called branch blocks. You're going to see, this is what I told the jury, you're going to see a video of how branch blocks are done. You're going to see a video about what's called radio frequency ablations, and then did physical therapy. But it all didn't work. So my client had all these surgeries. And I want to leave this screen up as long as I possibly can, because in this case in particular, I didn't love my liability side. I didn't love the facts of the crash, but I loved the injuries. So I'm leaving this up as much as I can. When I tell the jury what a discectomy is, I'm telling them there's this thing called a discectomy. Here's what it is. You're going to hear this from the doctor. You're going to see illustrations that shows how it was done. A disc replacement. Well, you might not know what a disc replacement is, but it's when they grab a disc out of your spine, your spinal column, and they pull it out, and then they slide the disc back in, an artificial one, a plastic one. Tell the jury that's not exactly how it is. It's not perfect, but that's the general idea. But you're going to hear from an expert who did this procedure, who's going to tell you exactly how it worked. And then if your medical bills are high, you want to put the number up. If your medical bills are high, you want to put the numbers up. Okay. So I've gotten through with duty, breach, cause, and damages, how I'm going to prove that, and I've given the injuries. So we're now at a place where I could ask for money. I mean, think about it. There's $567,000 in medical bills. Ladies and gentlemen, that's why this is a $6 million case. And then you just say it. Have no fear. Just say it. There's a lot of debate. Well, then the defense knows how much you're going to ask for. So, well, then they can criticize how much you're going to ask for. So, that's my current thought is kind of so. Tell them. Tell them. I think by telling the jury, especially if it's a large number, telling the jury in the opening statements gets them over the sticker shock. And I'll tell you, I've already told them that it's $1 million case, multi-million-dollar case in jury selection, assuming I'm allowed to. So especially if I haven't said it in jury selection, I want to say it again. The idea, I call it the Trump theory, politics aside, that dude runs around saying he's the greatest at everything, whether you believe him or not. He runs around saying he's the greatest at everything. Muhammad Ali, I'm the greatest. Floyd Mayweather, I'm the greatest. Michael Jordan, I'm the greatest. Well, regardless of whether you believe that stuff, if you say it enough, people will believe it. So if I keep telling the jury, this is a $6 million case. This is a $6 million case. Hey, this is a $6 million case. I think they have a better chance of believing it, especially when the other side isn't saying, no, it's a $500,000 case, because they're not doing that. So you can do the ask after the damages because it is an easy transition. After your damages or after you do that ask right there, I think you want to transition to the defense case. You want to transition to the defense case. Now, it is an opening statement. You cannot argue. But you can preview the defense case. You should only do that if there are things the defense are going to say about your case that you haven't covered in the opening, specifically bad things. So if the defense has a great witness, I think you have to introduce that witness for the defense and minimize that person. So if they have an accident reconstructionist who says, hey, this crash wasn't the defendant's fault, it was totally the plaintiff's fault, I think you have to say, you're going to hear from the defense that they have an accident reconstructionist That accident reconstructionist has been hired by those defense lawyers, the best ones money can buy, 100 times. It's the go-to person for them. And he's going to say that the defendant didn't cause the crash, my client did. But you're going to hear he didn't do a very good investigation. And I can't tell you about all the reasons that he didn't do the investigation, a really thorough investigation. But I will. Just remember, though, when that person is testifying, think about all the things they did, but also think about the things they didn't do. Because later I'm going to come back during closing statements and tell you and show you all the things they didn't do. And you'll hear that during my cross-examination too. Now, sometimes defendants have pieces of evidence or witnesses that you're not sure if they're going to call or show. So they may have a witness, for example, comes up in my world a lot, a billing expert. Roll my eyes at that. There's no such thing as a billing expert. But they might have an expert who says that the bills are too high and they're unreasonable. This is what I see a lot. But you don't know if they're actually going to call that person. There are times when I want that expert to be called. There are times when I want an accident reconstructionist to be called. There are times when I want them to show a piece of evidence. So I tell the jury, they have this. I'm sure they're going to show it to you. They have this billing expert. He's going to confirm, this is usually why I like billing experts. He's going to confirm that my client's bills are $567,000, that there is absolutely no dispute that that's how much the bills are to my client. And that billing expert is going to confirm that without a shadow of a doubt. So everyone's going to agree on that. Now, what have I just done? I've taken their expert that maybe they don't want to call, or maybe I'm not sure, and I've put them in a box. Because if they don't call that expert, the jury goes, wait, what happened with that? Why didn't they call that guy? Or they pretty much have to. So you can share my screen here. You can address the defense case, force their hand if necessary, and you can ask them to do something. I see a lot of times in smaller cases, the defense will try to steal the last close. They won't put on any evidence because they want to close. If the defense doesn't put on any evidence, they have the right to close last. The plaintiff doesn't get the right to rebuttal. So what I've done before is I end towards the end. Why are we here? And it was Encompass. I was right. Encompass has broken their promise, or maybe they haven't. Maybe Encompass hasn't broken the promise. Maybe we have this totally wrong. You all know about Sherlock or Matlock or Perry Mason, Law and Order, Boston Legal, hell, even Suits. What's so great about those shows? Because in the middle of the episode, or maybe towards the end, the one side comes out and has this incredible aha moment. Maybe that's why we're here. Because the defense has that aha moment. If they do, folks, I don't know about it. That's the only way that they can win this case, is to have an aha moment, and it must blow you away. I'm setting the expectations so high for them. And I know that there's no aha moment. I know they just want the last closing. But then when they do that, when they take the last close, I get to say in my closing, where was the aha moment? Why the hell are we here? Well, we're here because they've broken their promise. So I'm looking for ways to dare them to do things, or force them to do things if I want them to, or to answer impossible questions. Here are the two questions I think that the defense should answer in this case, and they have to be impossible. You cannot put a question up that they will answer. Hilliard Castilla from Walden Edelman, I put up these questions one time, and he grabs a marker and he walks over to the board. The first thing he does when he stands up, and I'm like, shit, he's gonna answer the questions. Why did I do this? I'm sitting there. And what he does is he crosses them out and says, I was born at night, but I wasn't born last night. These are unfair questions. I'm not going to answer them. And I was like, thank God. So just make sure that you really can't answer those questions if you put them up. So after you get done with the defense case, you can then give another ask if you want. Or you can go back to your theme, encapsulate the importance of the case, and ask for money. If you don't want to do that, you can go theme, importance of the case, and I'm ending with my win statement. I'm ending with my win statement. So the first thing that the jury hears is my win statement. I'm incorporating the win statement throughout the opening in different places. I want to say it once in almost every section. And then I want to say it at the end. I also want my witnesses to say it, or at least I want to introduce the idea of the win statement during direct examinations and cross-examinations. Remember the win statement that was my client did everything right? I'm asking the police officer, hey, did my client do everything right? Yes. Are you sure? Yeah, he did everything right. I'm asking his doctors, hey, did he do everything right? Did he go to treatment? Yeah, he did. So he did everything right. Yep. And I'm trying to get them to parrot it back. It's almost, if you watch like a 60 Minutes or a Dateline, a lot of times the interviewer will say, Keith Morrison in his Keith Morrison voice will say, so you were really scared? And the person will say back, yeah, I was really scared. So I'm trying to get my witnesses to also say the theme. At worst, I'm saying it throughout the case. So that is, and let me show it to you one more time. That, or this is, I think, the repeatable process that you can use in order to structure your opening statements. I will send this out to everybody. So don't worry about that. I will send it out. What I think that some of the takeaways for an opening statement that you should be thinking about is that you need to know your win statement well before you start video for trial depositions, because you're going to want to introduce that win statement before the opening. I think if you can introduce your win statement in jury selection too. You know, who here thinks that it's important that businesses don't invite dangers, that they don't allow whatever? Who here thinks it's important for insurance companies to keep their promises? And you've already introduced that idea. So it shouldn't be the first time they hear about your win statement. The last thing I want to do here is probably the most fun thing for me. I want to show you, in the last 10 minutes here, I want to show you some ways that I believe are effective when you're delivering your opening statement. You don't have many CLEs or even webinars that I've seen, I think because people are afraid to get out of their chair. You don't have a ton of webinars that show you how to present. So I'm going to show you some ideas that I have on how you're going to do this. And I've shown you how I'm going to deliver the win statement. So bear with me here while I stand up again. And I want to show you just some concepts that I think have worked for me. I want to make my opening statements as dynamic as I possibly can by using visuals, by using Prezi, which I dumbed down Prezi pretty significantly. Prezi does some incredible things. If you actually watch one of the CLEs on my YouTube, the Countdown to Trial, you will see Prezi in its full glory. But I want to talk to you about some ways that you can be persuasive in presenting your argument. So I want to use visuals in a whiteboard or on a projector. So I've got that presentation pulled up. What I also want to do is use my body and my movement. Everybody who's ever taken a public speaking class of some kind has probably heard you're supposed to move with purpose. What does that mean? Well, I hope to show you. So if you're my jury and you are right in front of me, and I have limited space here, so bear with me. But if you are my jury and you are right in front of me, I'm starting right in front of you. And I'm looking at all of you before I say the first words. And I'm waiting for everyone's attention. I'll stand there for 10 minutes if I have to. So I'm going to use the Tommy Wynn theme because that's the easiest one for me since I just did it a couple months ago. I'm looking at all the jurors and I say to them, Tommy Wynn did what he was supposed to do. Tommy Wynn did what he was supposed to do. You have to say things 3 times to make people remember him. And I want you to remember this. Tommy Wynn did what he was supposed to do. Now, I'm going to go into importance here. I'm going to stay in the middle of the room because I want to be important. Importance to me, at least, is in the middle of the room. But what I'm doing, if you can have a hula hoop on your feet around you, this is my importance area. Every time I talk about big picture, the win statement, the theme, and the importance, I am standing in the middle, dead center in front of the jury every time. So I get through with my importance. Now I'm incorporating movement as I need to. When I'm looking back at my client, when I'm pointing to the defense lawyer saying how great they are, when I'm pointing to all my boxes, whatever I'm doing, but I'm staying right here. Then when I start talking about witnesses or whatever it is, let's say law. So I'm going to go through the law. I'm then going to move over to a new area. I'm going to move to a new area. So I'm going to move to here. Now imagine a different hula hoop. Every single time that I talk about the law, whether in opening or whether in closing, I'm going to stand in this hula hoop, and I would be even further away. I would be further away from the center. I just can't go any further. So I'm going to stand here. Then when I talk about the facts, I'm going to come back to the middle, and I'm going to tell the jury, I'm in my middle hula hoop. I'm going to tell them, big picture, here are all the things that we're going to be able to prove to you, duty, breach, and cause. Now, I'm going to pick somewhere in the courtroom, and it's going to be my duty, breach, cause, damages. And every time I talk about each one of those things, I'm going to that area because I want to train the jurors that when I get to here, they know I'm going to talk about the duty. When I get to here, they know I'm going to talk about the breach. So I do that, and usually I use a square like I just did with you. Duty, breach, cause, damages. Then I'm coming back to the middle. And when I'm at the middle, I'm again telling the jury, big picture, the way I'm going to do this is I'm going to present witnesses, give you evidence. We're going to show you video depositions. Let me talk to you about those. Witness 1, witness 2, witness 3, witness 4. Every time I talk about the first witness, I'm going to my circle. Every time I talk about the second witness, I'm going to my circle, and so on and so on. What I'm trying to do is introduce some sort of spatial recognition to the jury. Fun fact, everybody tells you you should stand behind the jury box at the end of it so the witness can then speak to you. What I tell all the witnesses is speak to the jury as best you can, but I'm going to stand in a specific place. So when I do witness 1, when I'm directing witness 1, I'm going to stand in the witness 1 space. Witness 2, I'm going to stand in the witness 2 space. So on and so on. You can also incorporate some movement to show some important points of your case. So you also can use lateral movement, both forward and back and side to side. So when you're saying things like, I'm going to show you the first witness, the second witness, the third, and the fourth, move. Okay? You're going to hear that this, I'm starting way at the left. You're right, I guess. You're going to hear about all of these injuries. You're going to hear about all of these surgeries my client had. He had 1, this is what it was. He had 2, this is what it was. He had 3, this is what it was. And by the end, I will be as far away as possible because I'm showing them visually how much crap my client had to go through. How much crap my client had to go through. And if you've watched the damages webinar, and I'm sure I'll come back to this next week, I will use that movement especially when asking for money. Especially when asking for money. Because I will tell the jury on one end of the room are small cases where people are, go to chiropractors and then feel better. I will walk to the other end of the room. Hell, I've opened up the courtroom door and stood out in the hallway and yelled, this is where wrongful death cases are in terms of a damages component. That's how much money it is. If you're starting at one end of the courtroom, out the damn door is where the money value is for someone who's lost their life, has brain functioning problems or is paralyzed or somehow has something that affects them every single day. And then I'm walking all the way back and I'm saying, but this is all, I'm only asking for $6 million. And I'm showing that it's not as much as it could be. So in order to practice this, I would encourage you to find a mirror and look at that mirror and say this over and over and over and over again and practice every single thing from, are you going to put your hand up? When are you going to put your hand down? You're going to put both your hands up? When are you going to put them down? Because the opening statement is probably the only thing in the trial. Maybe your client direct, but even that, you're relying on somebody else. The opening statement is the only thing that you have full and absolute control over. So to me, there is no excuse to not be as perfect as you can be. I write my opening statements after discovery closes, way before the trial. So before video depositions, before everything, I write my opening statements, because if you don't know what the hell your case is about at that point, then you've already failed. So at that point, from the end of discovery, when I've written my first draft, and I'll tell you, I don't write, I can explain to you my process if you're interested, but I stand up and I say things. I walk around like a crazy person saying things. And if it sounds good, I immediately run back to my computer or iPad and write it down. And I just keep repeating it over and over and over. And I kid you not, by the time of a trial, I've said that opening statement thousands of times. There are 4 right now that I am walking around every single day saying. Seriously, I have 4 cases right now that 1 is on a trial calendar, 3, I don't know when they're going to try. I mean, I don't know when any of these are going to try with coronavirus, but I have 3 or 4. I have 1 that I know is going to try, and I have 3 that I'm pretty sure will. I'm walking around like a lunatic, talking all day, every day. I can't imagine. We have videos in our building, video surveillance. I can't imagine the security cameras probably see me in the elevators, in the parking garage, walking and moving and talking and being a freaking lunatic. So I think that you should make your goal to be that an opening statement can be perfect. It can be perfect, whatever that means to you. The very last thing I want to share with you, and this is a repeatable theme of my webinars, and it's important that I say it here. This is how I present opening statements. This is what makes me feel comfortable, and this is what I think helps me deliver my best work product. It may not work for you. It may not work for you. There are a lot of lawyers who do things so differently than I do. Lawyers I used to work for. I mean, I worked for one lawyer, and when I saw him in trial, my first gut reaction was, I want to be like him. I want to do what he does. And I tried, and it just isn't me. That's not who I am. I've tried I've tried to be other lawyers, and it just doesn't work for me. So besides the legal stuff and besides the storytelling and all that, opening statements is about being yourself and being comfortable with yourself. So if you can be yourself, find your confidence, which you can go to Toastmasters and speak in groups of people, you can present, you can do a lot of things to gain that confidence. But most of all, you need to be prepared, because that's the only thing I think that makes people confident. If you are prepared and you know that you are going to knock it out of the ballpark, you are going to be delivering a better opening statement. And the way to be prepared is walk around like a psycho, saying your opening statement, rewriting your opening statement, doing whatever it is that will make you comfortable up there. So my way might not work for you. This is one way to have a repeatable, effective, systematic approach to opening statements, so that 1, you don't have to recreate the wheel every time. 2, you can build confidence on every opening statement that you do, because every one that I do, I feel better about the next one. And a way that a roadmap that you can use. There's nothing wrong with taking detours. I mean, some of the best road trips have the best detours. If you watch any of the the Vegas Vacation or any of those movies, some of the worst movies, so some of the worst road trips have the worst detours. So you just need to be really, really prepared. So to recap everything, you want to have a win statement, a statement that, if true, you should win the case. You want to have a theme, a life theme that will relate to all the jurors: betrayal, responsibility, choices, those kind of things. You want to make sure that you stress the importance of the case, as well as putting a higher burden on the defense. Okay? Say their case is amazing. Say their lawyers are amazing, even if you don't believe it. Make sure your client's prepared to be on stage when you introduce your client and his family or her family. Have a very clear and concise way to explain the law. Make sure that it's going to track what the judge will later tell the jury. Okay? Make sure you break it down to practical terms. Negligence is about whether you're reasonable or not. Make sure that you are able to articulate your evidence, whether it's witness testimony, exhibits, whatever, and guarantee to the jury that they will see those things, because you're going to underpromise them and over-deliver while doing the reverse for the other side. After you get done presenting your evidence, or at least explaining what your evidence is going to be, you want to talk about the injuries to your client. Maybe do an ask at that point if it feels natural. Talk about the defense case if it has a purpose. You're only doing that if it has a purpose. If you need to minimize the persuasiveness of a witness or a piece of evidence, you have the opportunity to speak first and give it a tag or a category, or somehow classify it the way you want to do. And that can be a person or a piece of evidence. You can also dare or tell the jury that the defense is going to do something, and if they don't, it looks like they're failing in their responsibilities. You can also make sure that the defense has to do something, so that way you can be more prepared and you know what's coming in the case. You then can do an ask if you want, ask for some money. This case is worth this, that's what we'll be asking for. Otherwise, you're coming back to your the importance and the theme. You're ending with the win statement. That, I think, is the repeatable process. And I literally did not look at my notes while I just said that to you, because I repeat that every opening. I mean, that is my process. That's the process I teach law students and undergraduate students. And it's a process that I truly believe is one effective way for you to present an opening statement. If you have a different way, do whatever makes you feel the most confident and most comfortable. Maybe you can incorporate some of these things into your openings to make yourself more comfortable and make your openings more persuasive. And then move with a purpose. Have different points on the points located in the courtroom where you're going to address certain topics. That way you are not just using your words, you're also using your movement, using spatial recognition, and hopefully using some sort of visuals, which are limited in openings by what kind of visuals you can have, because you can't show evidence without approval from the other side. But you can have presentations, you can have a whiteboard, you can have a flip chart, you can have a PowerPoint. Make sure that you're speaking the juror's language, which nowadays is both audio and visual and fast moving, okay? So you need to respect the juror's time, and you want to move your case as quickly as possible as well. So I think if you do those things, you will improve your opening statements. If you have a different way to do things, please share them with me. I'd love to be able to improve mine. I thank you very, very much for joining me. I hope this helps you. I hope that you can get those trials sooner than later with what's going on in our world right now. I hope everyone is safe, healthy, staying out of trouble, and maybe questioning some of your long-held beliefs, whether it's about opening statements or whether it's about things going on in our world right now. So I encourage you to do that. I wouldn't blame you if, instead of walking around reciting your opening statements and practice them, you walked around and thought about the changes that maybe you can make in your life, or that you can affect in other people's lives to make this a better place, a much better place. I say this sitting here a mile away from Centennial Olympic Park and a mile away from Lenox Mall where protests have been. So that's not lost on me. I hope it's not lost on you. Wherever you are, I wish you all the best, and look out for each other.